Okay, we can make sound. Thank you, Ray. Good afternoon, everyone. Thank you for coming. I'm very pleased that we have such a terrific panel of distinguished general counsel, chief legal officers here with us today. The way I think about it is you probably came here wondering what the DOJ was thinking about your practice area, but at least you can hear what your clients are thinking. So let me just go through introductions. Let me see, I'll just do it in alphabetical order. Steve Crowley has been Ford's chief policy and general counsel since July of 2021. He's responsible for government relations, sustainability, safety, legal, and privacy. Prior to Ford, Steve was a partner at the Washington office of Latham & Watkins, focused on regulatory compliance and the environment. He was the Senate-confirmed general counsel of the U.S. Department of Energy after spending the previous 4 years in the White House on regulatory policy and legal policy. Earlier in his career, he was a special assistant U.S. attorney in the Eastern District of Michigan and a professor and associate dean at Michigan Law School. He did his undergraduate work in Michigan, earned his law degree from Yale, and holds a doctorate in government from Princeton. That's just one of these four, and I'm already getting a little anxious about being on stage.
That was kind of long.
Regina Jones, at the other end of this array, has been the Senior Vice President, General Counsel, and Secretary of ADM, Archer Daniels Midland, since 2023, and serves on its Executive Council. She's responsible for legal, regulatory, compliance, security, and government relations. Before ADM, Regina served as the Chief Legal Officer for Baker Hughes, a global leader in the energy technology sector, General Counsel at Delek U.S. Holdings, a diversified energy company, and has had various legal executive roles at Schlumberger, Dynegy, Shell, and El Paso Energy. She earned her BA from Sam Houston State, her law degree from South Texas College of Law, and Regina serves on the board of directors of the National Association of Manufacturers. Halima Delane Prado, to my right, is general counsel at Google, having previously served as vice president of legal there, and she's worked at Google since 2006. Prior to joining Google, Halima practiced media law, products liability law at Deckert, and at a predecessor firm of Ballard Spahr. She clerked for the Honorable Mary McLaughlin of the U.S. District Court for the Eastern District of Pennsylvania, had obtained her undergraduate degree from Yale and her JD from Georgetown, and among other things, she's on the board of the Leadership Council for Legal Diversity and a member of the American Law Institute. And last but not least, Kathy Rumler is Chief Legal Officer and General Counsel at Goldman Sachs, where she serves on some very important sounding committees, the Management Committee and the Firm-Wide Conduct Committee. She's also co-vice chair of the Firm-Wide Reputational Risk Committee and a member of the Enterprise Risk Committee. She joined Goldman in 2020 as a partner. Before then, Kathy was a partner at Latham & Watkins and chair of their white-collar defense and investigations practice. She was, as you probably all know, White House counsel in the Obama administration, having previously served as Principal Associate Deputy Attorney General and as Deputy Director of the Enron Task Force, as well as an Assistant U.S. Attorney in D.C. Earlier in her career, Kathy was Associate Counsel to President Clinton, a law clerk to Judge Timothy K. Lewis in the Third Circuit. She earned her BA from the University of Washington, her JD from and her JG from Georgetown, where she was the editor-in-chief of the Georgetown Law Journal. Kathy is also a fellow at the American College of Trial Lawyers. So I'm not really qualified to be on stage with these folks, but it's nice that they're all here to chat with you and to answer your questions. We'll have a few rounds of questions, and then we're happy to take questions from me, and then we're happy to take any questions from the audience. I thought it might be useful and interesting to start with investigations and the use of outside counsel in investigations, because at some point we pretty much all have to conduct an internal investigation, either that comes in because we have a whistleblower complaint, because management wants it, because there's an audit, or based on external pressures or inquiries. So, Steve, let me start with you.
Sure.
When one of these things, then the need for an investigation arises, how do you decide in the first instance whether you need to retain outside counsel or whether you can just handle it yourself?
Right. Good question. Let me not fight the question, but let me quarrel with it. I might not decide in the first instance. In the first instance, we'll start an internal investigation and then decide in due course whether it makes sense to bring outside counsel. I think to generalize about that, I would, and by the way, at Ford Motor Company, we have several internal investigations going at any one time. The factor that would lead me most to seek some outside help would be when the issue is either involves a lot of money, reputational issues, and I need to convey to my clients complete neutrality. Let me explain. I have great internal investigators, former prosecutors, a dazzling team, but they often are professionally acquainted with those involved, will have certain, biases or relationships within the company. And when I need someone to review email and documents and conduct investigations, it's helpful to have strangers. And when I get around to reporting the results of a robust investigation, it's helpful to me to be able to report, these were completely fresh eyes, not the professionals inside our company. So that kind of captures, I think, my rule of thumb, kind of a loose rule, but there you have it.
So Halima, once that decision has been made that outside counsel is necessary, what are the factors you consider when deciding whom to retain for that task?
So it's a little bit of a mixture. I try to keep to a rule of 3 to keep it easy. Expertise. We've got a fairly large company with a fair amount of business units, and so making sure we're using the right counsel for the particular issue at hand. And it's not going to be one size fits all. We actually kind of pride ourselves on not doing that. So truly expertise in the underlying subject matter, but also goes into a bit of a success rate. We need to see sort of how that outside counsel has performed in analogous situations over time. Now, success doesn't necessarily mean that you've won an actual trial or you've evaded insert name of sort of criminal claim here. It's more about the how they actually resolved it. And so having a true understanding of what that looks like matters greatly. I'd be remiss, we all have a P&L we need to budget, so I would like it not to actually break my bank. That matters as well. Underlying those 3 points, though, is truly a need for outside counsel to have a bit of a fluency or a finger on the pulse of the company culture. Why? You need to understand how we work in order to either, 1, investigate, 2, do that objectively, 3, actually have solutions that are tethered and tailored to our company to actually land them. It's not helpful for us to get a solution that we can't practically implement. So having outside counsel that can actually balance that is super useful.
So let me go to Kathy. In addition to the necessary subject matter expertise, so the track record of success, the familiarity with the company, is there a kind of a style or approach that you find most useful as you look for outside counsel to conduct investigations?
Yes, it depends on the type of investigation, but if it's a particularly sensitive one, then the counsel needs to be someone who I have trust in, that I have trust in their style, that I know that we're going to be able to work through it as the investigation unfolds, sort of in real time, and think about who to interview or how to interview somebody. And so, for me, really knowing the lawyer is quite important. Not in everyone, some investigations are more, I would say, perfunctory in the sense that you can kind of tell on the face of the allegation that it's not likely to be credible just on the face of it, and so maybe that's something that's a bit more routine, but something that is serious and needs to be dealt with a level of finesse it's important to me that I actually know the team that's doing it.
Regina, as often happens, as everyone in this room knows, sometimes it's not enough to have one lawyer or one firm on a matter. There are various reasons why you may need more. So when there are individual executives implicated as well as the company itself, how do you approach managing outside counsel in those circumstances?
So thank you for the question. I had a feeling I was going to be next. But first is, I would say, preparedness, in that you don't want to prepare for that scenario when it happens. You want to be prepared. So contemplating now what your ecosystem of outside counsel needs to look like in the event that you actually have some investigation at scale is really important. And so what do I mean? I mean, if you have business partner, strategic partner firms that you work with, that's going to be really important. But there's a lot of dynamics that you need to contemplate before it happens. So you don't prepare a soldier for war at war. So thinking through the scenarios of types of incidents you could have, that's a portfolio of what are the right skill sets you need to have, but also what are the dynamics around when that counsel needs to work together. How are you going to deal with potential conflicts? How are you going to set the right structure up in place? And so creating the concepts around what those ecosystems could look like, how quickly you can engage, because to the extent something occurs that you actually need to have multiple firms involved or have multiple representations, you've got to think through what level of representation does one individual need versus another. How is that firm going to interact with another firm to the extent they're with different law firms? And then how am I, in my role, going to engage with them in a way that it can be meaningful and productive and also pragmatic? So there are several variables, I think, that need to come into play, but as chief legal officers, we need to be really thoughtful about now what are those scenarios, and now what's my portfolio of firms needs to look like, so that I can almost in priority order say I'd start here, and then I'd kind of branch out as necessary based on those factors.
So is that you kind of have a secret panel of firms that you're already prepared to use when something like this happens?
Instead of picking secret, I'd pick strategic, because there's lots of dynamics that could cause you to go one way or another, but you do need to know who are those real key partners where if the shit hits the fan, I'm going to pull this card out and I'm going to call this person and then help now kind of build out the process from there. So you got to know where you're going to start.
Well, thank you for those perspectives. Hopefully they give some practical insight to outside counsel on how to position themselves and focus on what is needed in that context. Let's move to a couple questions on compliance. Kathy, you're the chief legal officer at Goldman, and your team is also in charge of compliance. First of all, how do those functions, are there ways in which those functions differ and require different management techniques?
Yeah. In a financial institution, the legal department and the compliance department are quite different functions. They work together on a lot of matters, but the expectations of the functions are very different from our regulators' perspective. The compliance division is a much different employee population, for example. We have a lot more junior people who are doing things that are more, I would say, kind of routine. For example, they're clearing surveillance alerts that get triggered on transactions, and so there's like it's a much more dispersed team. There we have people all over the world, and again younger team, and the expectation of the regulators is that the compliance department is the second line of defense, and they have a very kind of specific set of expectations about what that means in terms of challenging the first line and the business, setting the policies, testing, monitoring the policies, monitoring the controls, all of that kind of stuff that the legal team just doesn't do at all. And so the legal team kind of sits outside the traditional 3 lines of defense within a financial institution and is more advisory. And, you know, they're almost everybody in our legal department, not everybody, but almost everybody is a lawyer. So it's by definition a more senior team, and they are really working. Most of them are actually working kind of hand in glove with the business on, you know, on deals and trades and sort of, you know, commercial activity in a much more kind of proactive way. So it is a different way of managing those teams, because they really do have quite different roles, and they have, as divisions, quite distinct personalities, you know, if you will.
And I think it's an interesting point, too, that maybe counsel practicing the white-collar area don't necessarily focus on, that, you know, most of the legal team is dealing with commercial issues most of the time, and it's really the compliance people who are focused on the sorts of things that outside counsel are focused on.
Yeah.
Do you feel like regulators or the DOJ has been sort of focusing on, not to say picking on, particular sectors of the economy, like finance and tech, and do you think that's going to continue in this administration?
I honestly have no clue on that one. What I would say is this. Look, I think for financial services, I'll just speak about that because that's sort of, you know, what I'm most familiar with. I had worked, when I was at Latham, I had represented a number of financial institutions. I did not fully appreciate the regulatory footprint until I was actually, you know, working at Goldman Sachs. It is massive. It can be Byzantine. We have roughly probably 80-ish regulators globally. You know, we are a bank holding company, so we have bank regulators. We're a large broker-dealer. So we have, you know, of course, the SEC and their equivalents globally. You know, we have a large commodities trading business, so we have the CFTC and their counterparts. And so, you know, there's this just kind of matrix and you know, web of things. And as a result of that, I think financial institutions have the most complex and sophisticated compliance programs probably in any industry. And as a result, more stuff gets identified. And therefore, there can be a perception that there's more recidivism, if you will, in companies that are so regulated. It's almost perverse in a sense. It's like, well, you're a really bad actor. Well, not really. We're really good at detecting stuff that happens because we have such an apparatus to monitor, test our controls, and do all those kinds of things. So I do think that historically, sometimes that perspective has been lost on, you know, some of the enforcement agencies where, and certainly that issue has been politicized historically, right? That like, okay, well, X bank has had, you know, 6 different enforcement actions over the past, you know, 10 years. And so that is a nice soundbite, but if you really, you know, kind of look under the hood, I think it's a much, you know, it's actually a story, a lot of the times, you know, it's self-identification. And certainly self-reporting to the agencies. So I think those and tech is certainly coming, I would say, on, you know, behind financial services in terms of the kind of scrutiny that you know, the big banks have been under, you know, since the crisis, since financial crisis, you know, certainly.
You know, you prompt me to ask one follow-up question. Is the last, I think it was the last Deputy Attorney General memo that talked about recidivism, corporate recidivism, which is, you know, right, sort of what you're saying is implicated if you have an active program that is detecting stuff, but then suddenly you're putting yourself in the shoes of, you know, being considered a recidivist. Did you have, you know, discussions with the Justice Department that you can talk about? Were they receptive to that notion that, you know, the fact that you may have had 6 in the last whatever many years, doesn't actually
Not
qualify
us.
you as a recidivist?
Yeah, yes, I will say that, I think the industry has tried to basically make sure that nuance, if you will, was communicated. I think that the Deputy Attorney General memo that you're speaking of does reflect some of that, perspective. And, when the department is assessing the strength of a compliance program, right? They need to think about that in 2 ways. One is, how much has there been investment, and then again, is that program the reason that we're even having the conversation about a particular, enforcement matter? So, but the topic has been everything's a pendulum swing. So we're in the middle of that pendulum swing at the moment. But certainly I want to say, probably 2011, 2012, 2013, period, that period of time, there was, a lot of pressure from the Hill, in certain parts of the Hill, being put on, the SEC, for example, to really, you kind of remember the phrase "too big to jail" is one of them, but to really, really hammer those institutions that had, quote, recidivist issues. And it's like a blunt tool where there's always a much more complex story underneath.
Thanks, Kathy. Regina, let's go to you for a moment on, the substance of a compliance program. Obviously, the first goal is to deter misconduct, but it's also got to be a program that survives government scrutiny and helps set you up for success in an enforcement action. So what do you think are the keys to an effective compliance program?
So first of all, I think even in your question, the most important part of that is it effective? Because you can have a program that checks all the boxes that the DOJ sets out, but that doesn't mean it's effective. Now, how do you live and breathe compliance, and what does that look like within your environment? So you can have the programmatic framework set up, but then you've got to test it, because if you just pick something as simple as tone at the top, all right, there's tone at the top, there's tone at the middle. Oftentimes there's the term of the frozen middle, where you can say the right things at the top, but are people's actions really representative of and reflective of that? Do your processes and compliance program elements, do they actually work? Is your training effective? You can have training that's pervasive across the organization, but if people really don't understand what it means to them and what it means as part of their day jobs and how they make the right decisions so that they're self-policing themselves, then the compliance program is not only going to be ineffective, but the outcomes now will demonstrate themselves where it's evident and what happens across the environment. So I think we have to have an active mechanism to test the effectiveness of the program without having a government investigation come along to do it for you. We have to have scenarios where we're thinking through, if this happens, then would we have spotted it? Understanding the root causes of investigations, even that you're conducting internally. What happened here, what broke? And if it were to occur again, do we have the mechanisms and controls to make sure that doesn't happen? So having a mindset of recurrence prevention is actually something that's really important too. So it's less about the what of the program, because that's kind of the price of admission. And it's more about the how. How is it working? How do people see your compliance professionals? Do they look at them as now they're the internal police, where when they show up, it's because something went wrong? Or do they look at them as real partners that they can come to in a consultative capacity to say, what should I do here? And are they raising issues internally versus raising issues externally to agencies? And so it's about kind of the symptoms of compliance health. And how do we make sure that we're paying attention and learning not just from our own mistakes, but also from others, where we're looking externally as to what's going on around us and now testing our own controls to make sure that we're clear on whether or not that would happen in our environment. And if it did, would we have been effective in addressing the issue in a compliant way? So the final thing I'll say is I really think it's a test of integrity. We've even started using the words integrity when we're talking about not just compliance around the code of conduct and what we do, but integrity of our products and our portfolio, because it extends. And when you talk about regulatory agencies, there's a lot of overlap now between the traditional ethics and compliance and regulatory compliance, and applying the same principles to ensure that it all works and it works together.
So despite the fact that you've made every effort to make it work, to have an effective compliance program, nonetheless, something has popped up. You've decided who appropriate counsel is. Steve, let me move to you. You've been both in the government and outside the government. What did you learn about what makes an effective presentation to a regulator or to the DOJ when you're facing a challenge like this? Or on the other side, what have you learned now being in-house that you maybe didn't know when you were a regulator?
Sure, great. That comes up every day almost. I mean, I think as we engage on the compliance front, and it's typically regulatory compliance, our safety regulator, our environmental regulator, understanding the mission of the regulator, what constitutes a win, being able to put up kind of a tough defense, if you will, though, which usually it's shades of misfeasance rather than malfeasance or bad conduct, but in a way that acknowledges the importance of the regulator's work, their need to convey to their stakeholders, the public, the Congress, and so forth, the value of it, while, and this is from both sides of the table, educating them at the same time to one of Kathy's points about the complexity of our work. That's all very abstract. I'll give you a concrete example. Many of you drive cars, probably almost all of you drive cars with rear view cameras. The tech surrounding those is fairly complicated. In the early days, not that long ago, a rear view camera was a convenience item. It was something offered because people liked it. Today, there is no question it is a safety item, and the consequences of software imperfections and so forth raise important regulatory issues. But there was a period, a fairly surprisingly long period, where we were kind of somewhere in between. And I'm not sharing non-public information, all of the automakers have struggled with this issue of how to bring our safety regulator along, fight where we should, maybe don't fight where it's not a point, there's no point to it, and kind of engage in this, corny as it sounds, sort of two-way empathy where it's important the regulator understands sort of the limits and state of the science on the one hand, but where we kind of understand and appreciate the mission of the regulator and its, the duty that it owes the public. So I think it's sort of this exercise, this thought experiment, and what's the person on the other side of the table thinking, and what is success for them?
You just sent me back to, I was general counsel of USDOT when that rear camera rule went through. And
so you're the ultimate culprit. But I wasn't going to raise it. I'm glad you did.
Well, we had to work very carefully with OIRA on the cost benefit there, because it was almost a paradigmatic situation of there weren't that many deaths, but the deaths there were horrific.
Yes.
Little kids being run over by their parents or their grandparents. And
not in a Ford, incidentally, but go on.
But, and now it's kind of just part of the water we...
Yeah, exactly. That's exactly it.
Okay, so we, I think to a degree that maybe not be fully appreciated by the outside bar, we spend a lot of our time, I would venture to say most of our time, although my colleagues could disagree with me, on commercial issues, governance issues, proactive or other types of regulatory issues, and defending litigation. But one of the problems of all busy people is that you spend all your time thinking about the incoming and it's very hard to carve out time to think strategically about affirmative action. So, Halima, I wanted to ask you, have you, in your role with Google, figured out how to make use of litigation, proactive litigation, as a strategic tool?
Yeah, it's a great question and work that I think a good deal of my team is actually fairly proud of. We sort of hit a point where, to your point, we're defending, we're counseling what product can launch in what country, and we're thinking about it from sort of a harms-based sort of balanced approach, but also thinking about how can you get your legal team to really lean in and use not just their tools to actually help put out technology, but where we can actually use law as a tool to help our own consumers. So what do I mean by that? What we've tried to do is look across sort of the board, both with litigators and folks embedded with the product teams themselves, to identify areas where our products and services are being abused, the complaints, right, the customer service calls, the what have you, and really sort of engaging in investigation, our own internal, both from a technical perspective as well as sort of what I would say kind of more sort of in the weeds investigation, to pull up situations where we could actually, as an affirmative plaintiff, if you will, go after the folks that are taking advantage of our consumers. And so we've gotten a little bit more sort of in depth with it as of late, going after folks that were, convincing elderly folks to buy puppies during the pandemic with no puppy being delivered, to crypto scammers where folks were losing a lot of their life savings, and actually being able to work not just with the engineers that are building the Maps product or building sort of the search product, but actually the folks in our customer service and our technical sort of security teams, and building a case and then going after it, and looking across that not just within the US, but globally. And so it allows us to sort of really kind of flex our resources. We have a large legal team, and so it's an untapped resource and what we can do that's sort of anchored to the company's mission. And so it's been a nice balance as of late.
I sometimes struggle with the notion of whether to bring affirmative litigation when there are deterrence and sometimes financial reasons to do so, but the appearance of it, picking on a little guy or maybe defending a practice that is legal but not, publicly embraced, is a countervailing factor. So how do you think about those things?
Yeah, it's tricky, right? I mean, we're a big company. So if we go after what appears to be sort of a small group of crypto scammers, unclear who you're going to feel sorry for. And so what we really try to do is actually anchor it on the rights of the consumers who have been harmed, right? We have the ability to use our own sort of legal war chest, if you will, to actually fight on behalf of others. And we stay anchored to that principle. We kind of go through a fairly, I think, involved legal analysis before we decide to take action to really pressure test. What does this actually look like? Not that it's necessarily a benefit to us, but does it actually meet our need of protecting others? Another way of looking at it too is, can we actually create some sort of legal precedent that's not just beneficial for us, but actually for our colleagues as they do that same work? And so that means that you're not going to see us sort of filing, 20, 30, 50 lawsuits. You're finding that it's a bit more direct, and it's onesie-twosies, but we're super, super focused that it sort of checks all the boxes in terms of actual real-world impact.
That's interesting. Does anyone else have any experience with affirmative litigation that you'd like to follow up on? If not, we can just move to board relations. And again, this is, I was having a nice dinner with some very smart lawyers last night, and we talked about some of the aspects of effective counsel, and that some of the attributes of effective counsel is they really understand their client to the point where they understand the dynamics internally, the personalities of the other executives, what the board expects or doesn't expect in that particular company. We all have to, it's important to understand, in other words, your interlocutor or your clients, the pressures they're under and the relationships that they have to deal with. So with that predicate, we all have to make decisions with respect to whether and when and how we inform our boards about significant matters that come up, including investigations. So, Regina, let me go to you. What considerations do you take into account when deciding how to keep the board appropriately informed?
So that's a great question because the board, as you know, is a very important constituent when you're talking about big matters, okay? And I start with the basics, which is what does the board need to know in order to do what they need to do? So who has accountability first? When you just think about the various committees that are involved, what committee has accountability for what? So that's kind of one of your first measures you need to look at. Then secondly, what members of the board want to know certain things. Could be because of history, what you've given them updates on. It could be because of need or want or desire to know. And what framework you need to make sure you're balancing in the context of their broader oversight responsibilities. Because every board member doesn't need to know everything. And you need to have, though, a framework that we're working within. So first, looking at the charters to see who has responsibility for what. Secondly, engaging with the chairs of the committees and understanding now how does the role they need to play intersect with other committees of the board or other members of the board. Looking at the structure, do you have an independent chairman? Do you have a combined chairman-CEO role? Do you have a lead director? Now, how is the leadership of the board going to engage? And so all of those very simple structural elements have to be really assessed up front so that you don't get it wrong. Because you also have a duty to make sure that the board is doing the right thing and they're kind of protected, if you will, in the context of, that really important fiduciary obligation they have. So it starts with the basics and then it gets into now what have our protocols and practices been in the context of engaging with the board, and then what's the role that I need to play? Because in a real crisis, if you will, there's a few roles that are actually truly independent. And my client is the company. The board's client, quite frankly, is the company. And then you have management that has their role that they're playing, and that's a delicate little thing to manage at well, because it's all the way simply to, who participates in what meetings. And we've had instances where, let's say, it's the audit committee that's having a meeting on an important topic, but it's, for various reasons, maybe not appropriate to have the CFO sit in. That's a real delicate thing to try to manage internally when, they've kind of had accountability as that committee's core management liaison. Or what if you can't have if your chairman CEO is a combined role and you can't have your CEO chairman sitting in the meeting that he would normally chair? So recognizing that those nuances also have to be very surgically handled because rapport is important too. So it's something that I think should really, the principle of measure twice, cut once applies, because you also have to think forward and say, at the end of this, when everything we did is questioned, which it typically will be, now, will we be proud of the way this was managed, and will we have protected their correct interests the right way, and will we have held the right individuals accountable for doing the job that shareholders trust that they're doing?
Amen. So having decided that you need to update either a committee chair or a committee or the full board about a matter that's ongoing. Steve, let me turn to you. First of all, what makes for the most effective presentation to a board? You can put it in the context of, an ongoing investigation or whatever you like. And then, are there times when you would involve outside counsel in that?
Sure. As it happens, our board meets quite frequently, I would say. We have an intimate relationship with our board, family company. So we have kind of a natural forum for updates. It would be the exceptional occasion where we would make a presentation to the board. We can call emergency meetings and so forth, but in between that pretty regular meeting cadence, it does come up from time to time. If the board would otherwise hear about something in the Wall Street Journal, we will make sure that they hear it from us first. But mechanically, that would typically take a curated email. It happens to be our practice not to communicate to individual board members, but only to the board as such. The one exception would be an audit committee we have a special relationship with. All of this would kind of go through our chair. I send regular emails to the board, but with the awareness and blessing of our chair. Full-on presentations, again, we kind of have a series of meetings in which they get updates on long-running litigation matters, compliance matters, regulatory matters in a regular forum. It's exceedingly rare for my company to involve outside counsel in those. It's just kind of part of the month-to-month work that our in-house team does. On occasion, when there is a potential difference of interest between the board or the management, that would be a time when we have brought in outside counsel. But that's something that would be shocking to our board's culture as it happens. So it's not something we do.
Which is an issue in and of itself.
That's right.
They're going to be shocked when you bring somebody in the room.
That's
suddenly
right.
You're.
Yeah.
But on the other hand, I mean, I don't know if ask our other colleagues. We've had a practice, for example, of bringing in outside counsel, once a year. In fact, there's at least one in this room who's done it to give our board ethics training, or on the theory that. Not that our board, I hope, doesn't trust me, but that there's some things that are, nice to be coming from sort of an outside objective source. Are there anything, do any of you have that sort of practice, either with respect to ethics or with respect to some other issue where you think maybe we ought to have, trusted outside counsel come in?
I think it's situational, and so we try to sort of set that table, if you will, with the board, so that they're not surprised, right? And then you explain why this particular issue requires that. It's typically for the board's benefit, and so being able to actually communicate that it is for the board's benefit to bring in outside counsel, actually, it sort of paves the way for outside counsel to come in sort of with a, banner of trust automatically, but it also sort of focuses the board on the issue at hand, right? Without sort of, going off into other tangents, and so we found that to be very useful.
Yeah, and I think to add to that, there's also the element of, call it director development, but I'd say directors have to be equipped to deal with the issues. And the conversation, it depends on kind of what is the issue we're talking about and what kind of expertise or experts does the board need access to really understand the complexities of it, whether it be how the government's going to look at it or whether it be how the technology actually works. The board coming in with the understanding and consistent competencies around the topic is important. And if I use an example, let's say an accounting example, where you would expect the audit committee to understand it. Maybe they do, but maybe the rest of the board doesn't. Maybe you don't have, everyone isn't a financial expert, so how you bring everyone along the journey in parallel is really important. And sometimes it means you're starting with, let's just kind of set the playing field now so that everyone understands these are the types of issues, this is what it means. And then you show up and you can have intelligent conversations as facts develop or as internal aspects or dynamics are in play.
Well, if there's no other additions on board relations issues, let me turn to AI and innovation. I know that, as generative AI, has been growing, and everyone's saying, "Oh my God, this has got to become part of our, business life and ingrained into our business." Initially, I was thinking at United Airlines, what a fantastic tool. We'll take delivery of a plane from Boeing and Airbus, and we'll feed in a lot of data about the fuel burn and the size and the distance of city pair markets, and this tool will tell us where we should deploy that aircraft. And I think that's probably going to happen someday, but it ain't happening now. And I think my personal opinion is there's a lot of sort of getting over our skis on the impact of AI. On the other hand, there are uses of AI that have already been implemented to salutary effect. So let me start with Steve. What about at Ford? Are you either within the legal department or otherwise making use of AI in ways that are impactful?
Yes and yes, or at least yes and I hope so. So the company at large, we use AI routinely. Kind of to your observations, I think some of the kind of ultimate targets are a little more elusive than some of us thought. For the auto sector, mobility, pure autonomy, that's still a little, that's a bit out there, a form of AI. But coding, safety diagnostics, engineering, it's something kind of banal purposes maybe, it's something we use all the time. In the legal department, yes, more and more. I was a skeptic to be, or maybe a healthy skeptic, about how useful it could be for legal tasks. I've come to the other side, I think. So we not only use it in-house, we have a legal operations team that's 4 or 5 quite sophisticated data scientists, lawyers, who help us find efficiencies in our own work. We also insist that outside counsel use it. I sent a letter or so to all of our outside counsel that billed over a certain amount last year. It was not a popular letter, but asked them for a summary of how they use AI to keep our legal expense bills down.
So I have to interject.
Yeah, please.
I have not sent a letter, but
Yeah.
I have, every time I meet with our key outside counsel, I ask them this question.
Okay.
And I have yet to receive a useful response.
I see.
So tell me what your experience has been.
Good. So I sent a letter. The yield rate was not that great. So I sent a follow-up letter that was more clear-throated, which was politely, for you to continue to be a provider of legal services for Ford, we very much appreciate a response. And I would say it was a full spectrum. Some really great answers, some answers that were like fake answers that, we use Westlaw and stuff. So, but we are going to emphasize it more and more, both for our own work. And again, in some ways, like the real fruits or the immediate fruits are kind of the banal stuff. I spend a lot of my own time writing memos, probably too much of my own time, but I feel strongly about their tone and so forth. And so we've made, and this will sound egotistical, I actually mean it as self-mocking, we have a chat SPC, my initials. And so I can feed in, raw material or work product from my colleagues, and it'll spit out a memo that I could have written because that's the model it's trained on. But it's like that's a huge everyday time saving. So we're having fun with it.
So Halima, I think when we think AI, we often think Google. So not to put pressure on you, but how is Google leading the way on AI applications within legal?
So I was going to go on and have this whole laundry list, but I might just actually have Scott come to my department and talk about it. We've been playing around with it, right? It's hard to sort of work for a company that's putting out, and we've been doing AI for a while now, right? Check your Gmail spam filter, and that's AI. But sort of as we get into generative AI, really looking at where it can actually unlock capabilities for legal. And so I agree with Scott. It's sort of focusing on the more banal, right? Using AI to look across a body of contracts, if you will, to figure out, one, maybe just from a cost perspective, when you're dealing with, I'll get into the weeds, right? Limitations on liability, indemnity provisions. There are so much sort of commercial paper running through a company of any given size, and the amount of attorney time spent on negotiating the same fallback provision is inefficient at best, right? And then also for the attorney, from a career development standpoint, after you've done maybe 10 of these, you're yearning for that next thing. So we look for opportunities where we can use AI to, one, provide a bit more self-service to our actual clients within the business itself. 2, unlock the attorney's time to work on the really gnarly first-in-kind issues, be it a particular type of commercial negotiation or what have you, and then rinse and repeat. So that's sort of one example where we're seeing it in the commercial context. Also looking at it from a patent perspective. I know this is sort of more from a criminal perspective, but if you think about it, being able to look through dense amounts of codes, sentencing guidelines, you name it, what have you, and being able to distill a quick sort of summary that then the expert in the room can tinker with, can use to riff off of, to refine, to then actually translate that into a language that your clients can understand has been incredibly useful for our attorneys and even our non-attorneys. And then there's sort of the data aspect. We have a very large legal team. They're dispersed globally. My task is to figure out how efficiently are we working, be it from how much time we are spending on things from legal ops perspective, responding to certain types of legal notices, copyright claims and what have you. Where are the opportunities for AI to ingest that, detect patterns, and offer sort of repeatable solutions. And so we're playing with that as well. I think as it relates to kind of outside counsel and the question of sort of what have you done for me lately in terms of AI, a lot of times we'll sit down and have conversations with a given firm and say, let's knowledge share. How are you playing around with it? The form factor that you're using matters not. I mean, I do care a little bit, but truly, like, it's how you're thinking about ingesting AI is a way of having sort of a two-way dialogue where you're coming up with other use cases that might have been unfamiliar to us internally, but incredibly impactful for an outside counsel. And so we do a lot of that as well.
I think the notion that it is so far still sort of a incremental benefit seems to be a common theme. You know, for those of you who fly United, if your flight is late, which we hope is rare, you get a message on your app that explains hopefully why. And that actually turns out to be a message that is hard for an individual to personally assess and type for one of our 4,700 flights a day to inform all the passengers of what happens and so of what has happened. And so we have an AI tool that now will know that the aircraft was late coming into Seattle because of fog, and therefore it's late getting out of Seattle and headed to Denver. And that is an AI-generated message that is still reviewed by an individual, but I think we're hoping soon to get to over half of those messages will be AI-generated, and eventually all of them. Within legal, we found an interesting use in our labor contracts because maybe in other industries as well, probably not at Google and Goldman, but maybe at Ford and ADM. You know, these collective bargaining agreements are, you know, old, and they have a lot of stuff tacked onto them, and they're hundreds of pages, and you know, just figuring out something can be difficult. And we've actually fed them into an AI tool, and it's able most of the time to get the right answer. So that's been a huge time saving. But well, let me just follow up, Halima, with one question about AI regulation. I think this current administration has rescinded the AI executive order and processes that were in place. But you know, you are in the business of innovation, but there are positives and negatives. I assume you would agree to regulation, and you know, among the positives being sort of certainty and a level playing field, and among the negatives being squelching innovation. So how do you guys think about that?
Oh, we think about it all the time, but the how. So I think for us, if you start with the principle that any innovation that we want to put out in the world needs to be bold and responsible. Underlying that responsible is how do we grapple with the myriad of regulations, both sort of on the books and drafted globally. And that's a challenge. And I think sort of coming at it sort of from the idea that any type of regulation, I'll speak specifically on AI, where the technology is too important to society, the sort of nascent, you know, long-term benefits of AI seem clear, but because of that, it's too important not to regulate that technology well. And so what that actually means is truly engaging in dialogue with regulators. What are the harms in a specific use case that that regulator is worried about? And then having the dialogue to figure out how the innovation either safeguards against that or can be it modified or guidelines or what have you to prevent those harms from occurring. Because of, I think, the promise of AI truly has far-reaching sort of capabilities, that's a multitude of conversations, right? To sort of actually try to regulate it as a technology in total, I think, is actually quite difficult. And so having a more sort of harms-based dialogue gets to the core of it. It allows our engineers to continue to create. It allows us to explain sort of what the promise of the actual technology is, but sitting down with regulators to say, here's the harm as it shows up in a national security concern. Here's how the harm might show up in a medical context, and being very focused on regulating it in that context and not in whole. Now, do that across the globe, right? We've got a fair amount of attorneys and policy people sort of busy for days, but I actually think it's the right approach. And if it's AI or if it's even say 20 years ago, the notion of Gmail, the conversation stays the same, right? It's how do you sit down with a regulator to get them to understand the technology at heart, and then how do you actually address the concerns that their constituents might have with the use of that technology?
Well, let me shift to a last subject that is in the financial services world. Kathy, I read a piece that Mark Andreessen, who's been very public recently, told Joe Rogan that 30 tech founders, at least, have been debanked by financial institutions. And I'm sure this is a constant issue that is discussed in your industry, but how are you supposed to take the sort of compliance and regulatory perspective? How are you supposed to deter and prevent financial crime and manage the bank's reputational risk without closing bank accounts that are a little sketchy, like risky startups or payday lenders or crypto people? I mean, how do you balance the notion that you can't overreact, but on the other hand, you have to protect the bank and its customers?
Yeah. Well, let me say, we're into banking, not debanking. We actually like banking people. So that's our preference, is to actually, have clients and have customers. But the requirements that we have under the Bank Secrecy Act, under the anti-money laundering laws, under the various sanctions regimes, under just, the general laws globally are quite onerous. And, you will not get an enforcement action for filing too many suspicious activity reports. You will get one for not filing enough. And so the banks file literally, millions of suspicious activity reports a year, and are obligated to do so. And you always have to monitor if you have a particular account where you have multiple SARs that have been filed. The regulators expect that you will have a process in place, a governance process in place to assess that particular client and make a risk-based judgment about whether or not it's a client you can maintain. So I think, and that's, as it relates to, any variety of broadly defined, financial risk, financial crime risk. And then, when you get into reputational risk, and sometimes those two concepts, financial crime risk and reputational risk can be that distinction is not as stark as it might seem. If you just take cannabis, the cannabis industry has been a very tricky one for banks, right? Because marijuana is still unlawful under the Controlled Substances Act. Everyone in this room is familiar with aiding and abetting liability, and so but yet you have a number of state laws where it's fully decriminalized at this point and actually legalized in some jurisdictions, and so that's been a place that's been very tricky for the banks to navigate. Crypto, similar. The regulators have been historically, up until very, very recently, quite conservative around crypto. There can be a lack of transparency there in that industry. There has been quite a bit of, value going to places where it shouldn't be going, and we can't be in a position of facilitating that. And then another whole area is when you get into certain industries that at particular points in time become either unpopular, for example, the firearms industry, the oil and gas industry, and it's sort of traditional energy sources has been front and center in a lot of places. And so I think that basically from the bank's perspective, what we would like in an ideal world, and we know we don't necessarily live in that, but we'd like a set of clear, objective laws and rules. Tell us what they are, and we'll apply them. But I think what is difficult for us is when you have one state taking a particular position on an issue or on an industry, and then you have another state taking the opposite. And we're trying to figure out how to, as neutrally as possible, as fairly as possible, ensure that we're in full compliance with every law and regulation that we have to be in compliance with. And our regulators do expect that we have a framework for managing reputational risk. We have, as you mentioned, I vice chair. We have a committee. We must do that. We get examined on it. We get examined on how we, manage that process. And so we can't just ignore those issues. And I think one of the things that I know that Mark Andreessen mentioned was around politically exposed persons, or in the business we call them PEPs. We have a set of very strict requirements of additional diligence, additional surveillance, additional things that we have to do for customers who are deemed PEPs, politically exposed persons. So that's not because anybody at a bank has a particular ideological point of view or philosophical point of view, but this is what we're required to analyze.
So let me just see if anyone else on the panel has, perspectives on this management challenge, because some of what you said, is directly relevant to, what we're dealing with in the context of, clarity of a, single national rule, which traditionally has been protected by federal preemption in your area and my area. And now we have states that are making different decisions, and Texas in particular, requires certifications that you're not discriminating against gun ownership, or what we have found is that there are no footnotes or language changes allowed. It's like either sign it or don't sign it, and if you don't sign it, you're out.
Yep.
And so, and yet, like NHTSA, I don't think has been particularly descriptive of, automated vehicle requirements yet, and so you have different states. So does anyone have views about how, companies have to navigate through this patchwork of state, attempts to regulate that I think are increasing in the current era, because there's a lot of social issues that are arising that states are trying to, probably on both sides, trying to force companies to comply with. Does anyone have any views about that?
It's hard.
It's hard. So you got to understand that this is hard stuff.
No, that's one of the things. I mean, look, it's a very big challenge for us, candidly, because you do feel a bit of a whipsaw, and you have to just basically kind of try to muddle your way through. I mean, it's again through the sort of neutral application of the rules in the jurisdiction that you're in, and you oftentimes do have a conflict between the two, and you've got to you have to figure out how best to navigate it. And when you're in a global business, of course, it's beyond just what's going on with the states versus the federal government here, but then you're in other jurisdictions, and there can be a lot of conflicts.
Yeah.
There.
Especially in between Europe and America now, there's increasing.
Well, that's I think going to be the big, in my mind, that's going to be the big challenge in 2025 for us. Whereas that was not a space where we had to spend a lot of time thinking about. There was so much cooperation between, particularly in our industry, between the European and UK regulators in particular, and the US regulators, and so anticipating how that might change on the forward, I think is going to be a challenge for us. And not just from a regulatory perspective, but frankly, commercially, because our European clients have a set of expectations, particularly, our big public institutional clients that, they may have a different point of view than expectations that clients in the U.S. have. So again, it's that I think will be interesting to kind of see how the world unfolds and what that means for all of us.
Yeah, and I think if I could add to that, the global complexity piece, it's nuanced, it's very important, and it's moving at a pace that's hard to keep up sometimes. And you have to think about kind of your various stakeholders. So first you start with something is going to change. And if it's going to change, your government affairs or government relations group is trying to kick in to understand what that change could look like and how it could impact us. Then there's when it changed. It's now translating, whether it's through your compliance function or your business lawyers, this is what this means to you. You also have that narrative wrapped around it of what people are saying externally, whether it's through the media or otherwise, that creates a degree of paranoia whenever something's coming down the pike, that now your group is having to respond to, what does this mean, what does that mean, and that kicks up a whole nother churn. And then there's operational execution and compliance in the day-to-day. And all of those things are happening at once. And to your point, there's a dynamic of whether it's state or whether it's the EU or whether it's somewhere else in the world now with nationalism and everything else. How do you play in all those spaces where we come out and say, we will comply with the law wherever we are?
And certify.
All right. Right, and that is becoming way more difficult with the pace of change, the reactive nature, and then the final thing I'll say is your stakeholder, your employee stakeholder. Because even recently with the tariffs, we've had employees that have stepped up now under, I'll use the word solidarity to their own countries to say, hey, like for instance, if I pick Canada, it's that Canadians have a sense of how they feel about what's going on in their country and a loyalty there. And then you have someone else in the company who may be from the United States. And so it creates this internal dialogue on these topics too between your employee base. And so you have to be sensitive to not just complying, but with also even explaining to your employees, where does the company sit on this topic in the moment? And sometimes it's beyond we will comply and we will be prepared, but helping to translate now to our own internal stakeholder base of employees of now this is what it means to you.
You know, I think what all these disparate questions have in common is it's important for outside counsel to understand how their clients are thinking, what their clients' focus is, preoccupations are. So some of these things may not seem relevant to your practice, but I think what is universally relevant is, like, you got to understand what, you know, how important is this issue to my client? How much of it is it just an annoyance that they hardly, you know, think about, or how much is it central to their strategic, you know, day-to-day? So anyway, we've got 15 minutes left, and I think this is a good opportunity with this, you know, incredibly distinguished panel to kind of learn what they're thinking about issues that matter to you. So I don't know how we open it up, but feel free. Yes, sir?
He's coming.
Microphone's on its way.
Thank you. These are wonderful remarks. Thank you for joining us today. My name is Bobby Earls. I'm a litigation partner at Cooley in Chicago. And I had a question really for all the panelists and the moderator. And it's good to see Chicago like well represented on the panel. But I'm curious, I think we're all curious, like because of the incredible rate of change in the regulatory environment, sort of how you, as you know, as the leader of these very large legal departments or very large companies, are spending your time, because it's like you already have the job of managing, like doing the blocking and tackling of the, you know, managing the legal department, which is like more than a full-time job on its own. But then what I imagine must be a big role of counseling the leadership of your business, you know, about this is what we can and can't do. These are how the rules are changing, sort of distilling that for them, you know, on a concise basis. So I'm just wondering, you know, among those roles, you know, how do you find yourself sort of spending your time these days between those two things? And I guess then also as outside counsel, maybe what can we do, or are there ideas that we could do to help you manage that, you know, this situation?
Yeah. Do you want
I can start. I view it as kind of three areas. One is counseling your leadership and sort of governance issues. Another is managing the legal and other functions. But I separated out to sort of counseling your peers in their particular challenges, and understanding what their key projects or challenges are. And I think getting that balance right is very hard. And I will say just one comment, which is I think you get pulled away from managing the legal function because your leadership thinks that's the least important thing you do. So, people can have different opinions about whether that's correct or not. But I don't know what our colleagues think.
Well, I think it's really important for people in our positions to make sure that we are counseling both the board and the senior management about the longer term, and not just thinking about, okay, the here and now. And I think that's happening to all of us, because there is a lot of rapid change. Let's just take cryptocurrency as one example. So there is no regulatory legal framework for crypto today. There isn't one. What we have seen is a shift in enforcement priority, and but that does not a legal framework make. So you sort of have to think about, while there might be a lot of enthusiasm about, okay, like let's go, go is probably not the right answer, because you have to think about not only what framework might develop, but then how that framework might change over time. And I think that's true for a lot of stuff that's going on in kind of the deregulation area, because again, pendulums swing, and there are certain things. Well, for this room, let's just take the non-enforcement of the FCPA. Okay, what does that mean for us? There's still a UK Bribery Act. There's also, again, this is non-enforcement. That position could change, and it could change, in a year, or it could change in 4 years. And so, what do you do? Do you just all of a sudden say, okay, well, I guess we can start bribing people? And other parts of the world, probably not. That's probably not wise. And so, anyway, I think that it's important to have for us to be a bit level-headed, and a bit sort of damping down some of the enthusiasm that might be generated by a lot of pretty significant actions that many of us really haven't seen before. So I don't. You all might disagree, but at least that's kind of been my approach.
I'll tell you what I need.
Yeah, go ahead.
This is for anybody in the room, is that there's a lot of activity everywhere globally. And what happens inside a company is when things happen around the world, you wake up every day and there's like 15 things that happen that people within your company care about. We're in 190 countries, all right. So the list of things that have started with internal emails saying, this happened, what does this mean? This happened, what does this mean? What is this? What's going on in the US? At the end of the day, to the extent I have outside counsel partners that know what our strategy is and what really impacts us as a company, but also can translate now interpretations, because we get all these legal alerts of this happened and this is what it means. Very legally worded, if you will. So for me, I can read it and I understand it. I'm not the one that needs to know the most. My leadership wants to understand. Our business leaders want to understand. So then what I have to do, or my team, is take all of that and translate it into something that people can actually interpret. I.e., your FCPA example was a perfect one. Because around the world, Everyone's asking my team, and in spite of the fact that we can say, oh, we've got 500 people around the world, there's not 500 people that can answer 40,000 people's questions on what does that mean to us. And so to have really simple narratives on really important legal topics that can be turned around and now provided to others to give them context on this is what it means to you. That's, I think, one of our biggest challenges is translating, because it creates a lot of churn. If it's any of the topics of the day, particularly in the US, but all jurisdictions, is answering the what does it mean, not what does it say.
And also, I think not having the opinion stop there, right? A lot of times we'll reach out to you for advice. What does this mean? How do we apply it? We get a definition of the law, which may or may not be in legalese, most likely needs to be turned again. But then it's missing that critical point of, will it be challenged? How can it be challenged?
Right.
How long will that take? What will that cost? And for many of you, you work for global firms.
Right.
Thinking about the advice that you were given, understanding that your client has a global footprint. That is really helpful, right? Yep. Looking at it just in the narrow context, I can't operate in the narrow context, right? A lot of our products are ephemeral. And so I need to be thinking and really appreciate that advice that says, this law has been passed, here is the flow down. A lot of you also have government affairs folks within your orgs. Having a finger on the pulse of how that is sort of impacting similar regulation in a different jurisdiction, super helpful, right? While we ourselves in legal work closely with our public policy teams, we don't map to the entire globe, right? We couldn't possibly. And so having sort of outside counsel that is really focused on the global footprint of us as a client and the implications, that's gold.
Yeah, and not to harp on this, but I guess I am harping on it, because this is a really, really big thing for us, because those are the questions we have to answer. And the challenge with law firms sometimes is we're still in what we call in corporate silos, but we're still in practice groups, all right? And we're still in countries. And when I say we, I'm talking outside counsel for the moment. But we're not. We're everywhere. And every issues might have 7 different practice groups involved in kind of translating what it means. And it might be 10 different countries where it's really important. So being able to take that and translate it into, but this is what it means to you, that requires collaboration at scale within the law firms. We have to do that. We have to figure out how do we provide the legal solutions to the real business problems. It's not in practice groups. It's not in countries. It's taking that entire ecosystem and then coming back with this is what it means to you. And you have the knowledge and expertise, but sometimes that network of the law firm is not being used to align with the network of the real corporate issues. And I think that's golden. And there's a book I read that I think is important. It's What Got You Here Won't Get You There. We're going to have to do legal differently moving forward. And the fact that external counsel sometimes moves at a different pace than in-house counsel, we need to bring that together, because right now, every single issue that comes up, it's in one of our domains. So how do we make that now more efficient, effective? We talked about AI, but how do we make it into something that's really meaningful and helpful to deal with the real tough business challenges of the day? That's, I think, really important for external counsel.
I'll make this observation, at least speaking for myself. The market for advice about what's just around the corner is saturated.
We'll pay extra for that.
Well, I'll pay extra for information about the long term.
Yep.
Europe will see a reckoning between policymakers in Brussels and London and in member states between their industrial policy goals and their climate goals. Those are coming into conflict, and that conflict will be increasingly acute. But how that reckoning will be done, $1 million question, $1 billion question. The global trading system probably will settle out into more regional blocks. I don't take too much stock in kind of the tariff controversy. We'll see how that dust settles. But over time, there are forces that would suggest we'll see regional markets rather than a global market. But exactly what that will look like is the billion-dollar question. So kind of to the spirit of your question, I mean, I spend most of my time managing up, or my CEO and board on these long-term trends, and they expect me to have as good a bet as anyone else about them. And I find myself fairly lonely in that market. Mm-hmm. But what Congress is up to, if I need to know, I already know, and if I don't know, I don't need to know. So anyway, I'm just trying to be practical about where there's sort of where there's a gap. Yeah. There's a bit of a wisdom gap, and there's a surfeit of a certain kind of work.
Looks like we may only have time for one more question. Anybody want to jump in?
Hi, great panel. I'm Bruce Segaris from Washington. So my question is on compliance conversion. Convergence. So there's several areas like tax, where we've got these global disputes over both the global minimum tax and digital taxes. There's anti-money laundering. There's now corruption, anti-corruption, sanctions, data, and we have, in all of these areas, a lot of changes, disputes with our allies and neighbors. And so how do you, but because a lot of them are also interrelated, how do you do compliance convergence with all of these challenges which you've discussed?
So one of the things that we do is compliance is not owned by the legal department. Compliance is owned by everybody. So if there's, if it's the tax example, we've got our head of tax sitting with our person in compliance, sitting with our people who's part of the business that tax element may be impacting the most. And we're all kind of churning around, what does it mean for us to be able to comply with this rule? When do we think it's going to happen? What is it going to mean? Where is it going to go? Because then it's linking to the business strategy. And now how's it impacting the strategy, and what investment needs to be made now? And are there scenarios where it may or may not happen where we need to be prepared for both? So it's the collaboration piece for us that's really important, in making sure we bring everyone that's potentially impacted along so that we get it right.
And it's changing all the time. I mean, that's, what's one of the other things, and it's, of course, it's frustrating because when there's so much volatility in the regulatory world, we waste an enormous amount of time, working on one thing, then it changes, and then it changes back, and then it changes again, and I think from the business community's perspective, that's probably one of the single most frustrating things, because it's distracting from other stuff that we need to do, but it's also just takes a huge amount of people and resources, and sort of regulatory change management, if you will, is massive. And then you inject this level of volatility into it, and it's really quite difficult to manage.
Well, on that note, I'd like to thank our panel.
So there's lots of things for you all to do, notwithstanding that there's no more FCPA.
Thank you very much for coming.